Let's get this re-going again. The whole gang is here, all three of us.
So we should indicate for the record, Mr. Chairman, that this is a continuation of the board's meeting of July the 18th that was not adjourned but recessed until a time certain today. So we're reconvening the meeting. It's 1 o'clock and today is Monday the 21st. Zach, can you kind of on background provide the board with what transpired over the weekend?
Sure. As directed immediately after the last meeting.
I don't see anybody I can identify as Scott Truppin.
Okay, go.
Okay. As directed at the last meeting, we sent the counteroffer you all approved to Mr. Prepham's attorney. We have not heard back yet, although after talking to his office this morning, I understand he's not in the country. We've also sent him draft settlement agreement and all the exhibits which we're prepared to talk about and go over today. There's one major missing item, which is the cost per ERC. I don't know if Mr. Prepham, who I believe is on the call here, has had time to look at any of these materials because I don't know what his attorney has sent him, but I assume he can assist him.
I can't hear you. Is this Scott?
Yeah. Yeah. Can you hear me?
Yes, sir.
Yes, sir.
Yeah. Where do I start? So my attorney's in France. He's on a family vacation at the Louvre. I did get 10 minutes with him this morning early, but he hasn't really had the chance to look at much of anything that you've sent over to him, again, because he's on a family vacation. So, having said that, we did have some brief dialogue when he split away from his family. Just the FYI also, my partner Ken McLaren, I believe, is on. That was Ken and Jelna who were doing the screen share. I think that's off. I'm assuming he's on.
It appears to be so, yes.
Okay.
Yes.
So he's hearing this. So we've been working on this all weekend. I'll tell you that. I'm trying to look at documents that I was unaware of. I think the one that you referenced related to ERCs and the original development of the project itself. Let me start by saying that was, 7 years ago. And so I spent the weekend trying to review what documents we did have and what documents that I could find related to it. My understanding at the time, Paul Montes, and I'm looking at one of their documents, they took a look at anticipated demands, made some suggestions, but didn't draw any final conclusions about the ERCs themselves. I guess, hold on, this is Ken, just to make sure it's on. Are you on, Ken?
This is blocking Ken.
It should just be their mute button and
It's on the TV.
okay.
Oh.
Okay.
I remember there's
Give me 1 second.
Mr. Prepham, this might help. They
Okay, I'll just leave you on speaker, Ken, on this side so you can hear.
They need to click the join audio button. If they do that,
Can you hit the join audio button?
top
Ken?
left.
Okay, yep.
Okay, can you hear now?
It says test speaker and microphone audio settings. It won't go up to 39% it shows, but
There's a little up arrow, but if you just click the actual join audio button, not the up arrow, just the actual join audio button, you'll be able to hear us.
okay, hold on. Okay, here it is. It says phone call, computer audio. But it says failed to detect your microphone and speaker. Please make sure your devices are properly connected.
Okay, well, you may not have
Yeah, I'll just leave my phone on.
That's
You-
fine.
Yeah, that's what it
Yeah, you can hear okay. That's right.
Yeah.
So I mentioned, Ken, I don't know if you heard it, that I got a hold of Chris this morning. He's in France with his family, but I got about 10 minutes of his time. So he's briefly, aware of what we discussed on Friday, but he hasn't had a chance to have any substantial dialogue with the CID's attorney. Just FYI.
Can these guys hear you? Can they hear you talking or not?
They can hear me. Yeah, I got you.
I mean, they hear our conversation?
Yes. Yep, I got you on speaker. I have them on my iPad, so everybody
Okay,
can hear
all right.
everybody.
Okay.
So I said I was regressing a little bit. I think the most surprising element of the conversation on Friday was that this issue about ERCs dating back from 7 years ago became a part of the settlement agreement, and I had no knowledge of it. So, I mean, that was, where I spent the weekend trying to figure out what's what and look in the files and look at permits and things like that. So, I'm not 100% of the way there, but I was just reading off one of the documents from Whole Montes where we're trying to figure out anticipated demands and making some suggestions, et cetera, but not necessarily drawing final conclusions. And so, my initial reaction to the settlement agreement, I had heartache about two things. That one in particular. The other item we had a little heartache on was the idea that the board would roll back the ERUs to 0.25 and 0.50, which is what they did about a year and a half ago.
Mhm.
But I understand that maybe legislatively they can't commit to a longer term time frame about leaving those alone, which, if that's the case, exposes us to the same thing happening again, what happened last year. So curious your thoughts on that one. And then the ERC element is, interesting and, but complicated at the same level. So my initial thoughts are, if we can, agree to the rest of the items, remove that element from the settlement agreement, just set it aside for us to work on that, because I haven't had time to digest, even understand what our position would be on that yet. Not saying yes, I'm not saying no, but to rush to say, yes, I agree with something at that level, which potentially might cost us a significant amount of money in such a short time frame, I don't want to be part of the settlement agreement.
Let's go step by step on this. Let's handle the first one where you were hoping to get the longer lock-in period for the 2.5 and the 0.5. Zach, can you explain to us why that's not feasible?
First and foremost, as a elected body, you cannot basically bind future boards beyond just enacting your resolutions, right? Future boards can always come back and make their own determinations. They can do their own assessment methodology and arrive at a different conclusion. So there's just not a tool available to you that is what I would call unmodifiable. That's the why it's not. We can make this change now. We can all agree that this is a change that is supported, but to say that it's unmodifiable, that's just not something that is a tool that you have.
So it isn't even whether we have a choice, it's that we can't do it, right?
There's no way to do it. Like, for example, right now you guys are modifying utility rates. You can, when we do that, we couldn't, for example, say, and we'll never change utility rates again. So it's basically just, all you can do is make a legislative modification at one time, and then later boards could change that at a different time. However, presumably, as I understand the conversation, if future boards were to do that, they would presumably be a challenge as to that decision, and that's I think the only comfort, the comfort that I see here for the property owners is that they're not, if this were to become an issue later, they would be able to bring forward litigation at that time. Because to remind everybody, there is no current litigation as to that issue. So it's not like we're dealing with something that has been litigated for years and then we're going to go back and litigate it again for years. It's never been litigated. We're taking an opportunity here to avoid litigation.
Scott, do you understand our attorney's position on this?
I understand it. It's effectively asking us to carry that burden of, having to have that exposure when we're trying to bring some long-term conclusion with rates staying the same. I get it.
I understand you're trying to get it, and what he's telling us is we can't give it. But
I think that there are other things in here that can be given that are present. For example, and I think that's the significance of the ERC component of this. The part of what is being proposed in the draft and settlement agreement is a release for ERC payments that were not collected. So I think that that's a show of good faith of trying to have give and take on both sides. that makes it worthwhile for all parties involved.
Relative to the ERC issue, I'm going to plead dumb on this. I don't have enough data to effectively evaluate it myself, especially without the counsel of my attorney being in France to make a
completely
decision in
understand
that short period of time. I can't do that.
And let me just say, when we talked on Friday as a group, and we talked about sitting down again, I had expressed concern about it being on Monday because I wanted to make sure that your attorney saw these at the time. I don't think you knew he was in France at the time because you
Did
indicated
not.
he would jump on this right away, which I'm sure he would if were he not in France. But now that we know this piece of information, I think it is paramount from my perspective that you all cannot. Advice of counsel is critical for all parties here. We definitely need to have all parties reviewing this under advice of counsel. And so I don't know now knowing that he's in France, I don't know how you want to proceed on that front. The point of today was for the district to do everything it possibly could to avoid everybody having to do trial prep. And so we have since Friday gathered exhibits, drafted settlement agreements, and provided your attorney every single piece that we could think of. If there are more specific questions that you want, we can try to get those answers as fast as possible. But really more to the board on our side. What I'm not sure. Do we want to talk now, flesh out how we would go through ERC evaluation while we have this meeting? Do you want to wait until he's had time to review with his counsel? I mean, globally, in order to make the adjustments to the O&M allocations, it really needs to be done as part of the upcoming budget hearing, which is on August 15th. That's what's driving the time here. So the trial is obviously in September, but more importantly, this board is doing a budget adoption in August. And so that doesn't, as I understand it from your attorney's assistant, I think he's out of town until August 2nd. I don't know if that's correct or not, but that's what I was told this morning. If that's the case, we have time to convene again after you've reviewed with him. I think it makes sense for the district to try to avoid a trial and resolve 3 issues if possible. But part of that goes to, I think it's important that we're resolving all 3 issues, not just 1 or 2.
I will say one exercise that I have started. I understand the whole Montes as the engine consulting engineer. Their objective was to try and estimate what kind of impact the project itself would have on sewer and water usage. I guess my mind goes to, well, we don't have to guess. We have that data. So I've instructed my team to look back and see the data relative to how those rates or how that usage was effective before the project and after the project. So we don't have to do guesswork and make suggestions.
And I don't want to argue in this.
I mean, that's just logically where my mind goes.
I understand. The expansion approval, the Collier County site plan was approved contingent on the utility availability letter that your predecessor provided to the county, and that's where the 16.7 ERCs is coming from. And so if you didn't want to pay 16.7, it's not the district that you need to convince, it's Collier County. They gave you a site plan based on that utility availability letter. And so I don't think the district's in a position, and I'll let Neil weigh in, and we don't have our district engineer on the line today, but I don't think the district's in a position to change that number without knowing that Collier County would agree to change the number. And so that information has been sitting in the public records the entire time. So I just don't want to go back and re-engineer things.
We're not re-engineering anything. We're just looking at the actual data that they were trying to estimate way back when. That's all.
Neil, can you emphasize on that why, he's talking about, he's going back in his records and finding out how much usage they actually had on that property as compared to what the engineer proposed that they had the ability to access, and it's my opinion that if you have an ERC, it doesn't matter whether or not you use it at all. It's that you have the capacity on it, and therefore you have to pay the assessments for that reserve capacity. So, big Because what I'm looking at here now is if we would go back and look at the records of what his actual consumption was and try to backtrack how many ERCs then he should actually have, then we run into this thing where an ERC is 300 gallons a day per unit. Well, everybody could go back at their water bills and go, look at this. I'm only here 3 months out of the year, and you know, I only use an average of 25 gallons a day. So I only want to pay a small fraction of an ERC. But that's the slippery slope that we can't go down. And actually, our rules and procedures don't allow us to do that. Do you agree with Neil?
Yeah, I believe that is correct. The county has a land development code and subdivision regulations, and as a condition of getting a building permit, you have to go through site planning, and as part of the site planning process, the ERCs were developed and agreed upon. I'm not aware that you can reopen that process or try to change some of the assumptions within that. If that's what the county required to show that the district had capacity to serve that intensity of use, then yeah, I'd rather put that aside for now.
Okay, so what's next?
So that portion is so I would say there's three component parts to the settlement agreement. One is that, which is which is both the purchase of the ERCs and the fact that the ERCs, because they weren't purchased and haven't been in place for 7 years, they haven't been assessed for those ERCs for 7 or so years. The second component of the agreement is the reduction to 0.5 and 0.25. I've sent to counsel for plaintiff the site plan that's on file with South Florida Water Management District that I believe is the correct allocation of which slips are the liveaboards, and I'm just looking for some confirmation on that because Neil needs to know exactly which slips will be getting which O&M allocation as part of this if we're moving forward in that direction. So that's the big piece too. If that's I don't know, and I don't know again if that's mutually agreeable, but that's what we need to know to get there.
Okay, I'm confused.
I could imagine that's much of a question.
Okay.
And then the third piece is agreeing that the lawsuit. So the lawsuit is not over the one; it's over the original allocation method. That will be dismissed basically as part of the larger agreement. So all of this is and all supervisors, you've been provided copies of all drafts, and then Mr. Prepham, your attorney's been provided copies of all drafts. I don't know what the most efficient way to get everyone in review of these is. So I guess we could talk about that. But from the board, what I need to know is how we're going to value the ERCs. But what I'm hearing from the plaintiffs is that they're not sure whether they agree to that at all. But we can certainly talk about how we would value it now, or we can wait until a later meeting to do that. That's your call.
So Zach, we're talking about, the first issue was the ERCs, but that's the utility hookup, right?
Correct.
The second issue is O&Ms with the 0.25 and the 0.5 change. That's O&Ms,
Correct.
right? Okay, so it's,
No.
yeah.
Well, that's ERCs.
0.25 and 0.5 is ERCs. Not O&Ms, it's ERCs.
Yeah, but those are, if they're utility, it's gonna be going away.
That has nothing to do with this.
The Neil, please confirm the O&M allocation for the dock slips is 1 right now.
I believe that's correct.
And so what we're proposing doing is reducing the O&M allocation to the boat slips to 0.5 and 0.25, depending on whether it's a liveaboard slip. So
That's correct.
that's the O&M allocation. The ERCs, the entire marina is pursuant to the records on file with the county, short by 16.7 ERCs. So I would agree with the way that was just described by Supervisor Kish.
Well, from my perspective here, they're not going to be able to agree with us to buy those ERCs today. First of all, we don't know what we would charge for them, and we don't know how many of them that they need to have and that sort of thing. So I'm wondering, can we split that out of this discussion and have that at the next discussion? But for today, we're trying to settle the lawsuit. I don't know that the lawsuit, that we're going to be able to come up with an answer for all three of the legs of this that we're trying to do at once. I don't think that we're going to get past the ERC thing for the purchase number that we're saying that they needed to have for that permit. I don't think we can settle that today, but can we settle?
Talking, Scott.
Steve.
Yeah, it's up to your discretion 100%. But I want to just provide one piece of information. We do know exactly how many ERCs they need. It's 16.7. So we know how many they need. We did, but I agree with you that there's not a set value in your current rules. And so we can set that aside. I guess we just have to, what the rest of this looks like is the district agreeing to reduce the O&Ms and the plaintiffs agreeing to drop the lawsuit. But the plaintiffs are, just as a reminder, are not suing us over the current allocation. And so I think my understanding of the reason why the district, or the reason why our advice to not split this up is that the way it's going together involves the district resolving an issue that it has, which is that the ERCs weren't purchased. If we resolve the other issue without addressing that, I don't know. I mean, are we going to have to file a suit to get the other one moving? We're not. The district's not getting anything just yet. We're just agreeing to what they've asked.
Okay. Well, then,
Rebecca, Scott.
We can't, guys, may I speak for a second?
yep.
At this point, we can't determine that it's 16.7 ERCs either, because that is going to be subject to the levy that we put on them with the 0.25 or 5, or keep it at 1, or come to a better agreement for the district. But either way, you can't say it's going to be 16.7 till that's settled. So we don't even have the number.
No, and there's one other caveat in here too that I have started looking at is when we came on here as a board, we went around and we looked at all the properties, whether or not they had enough ERCs attached to them. One of them was the cell tower. We ended up assessing them at one point in a small fraction to on that cell tower. So then we started taking assessments for them, but we never made them buy an ERC. Same thing with K's, Mr. K down on the end of Wilderness K. He had no assessments on that property. We put 2 on there. We're assessing him now at 2, but we never made him buy the 2 ERCs. The gun club, the same thing. They were being assessed at 2 ERCs. We've changed it to 8. We never sold them the additional 6 ERCs. And what I'm looking at on this is the reason that this is a problem, because now we're assessing these people on capacity. When this was started, they went around and they decided how many ERCs needs to be, how much water capacity needs to be on all this property. They figured out it was 300 gallons a day, and they figured, so each property was assigned a number of ERCs, and that number added all together came up with 1,032 ERCs. You cannot add to that without adding capacity to the water treatment plant, because that's where our permit. So when we said we're going to start assessing more ERCs on this, those ERCs have to come from a different property. We only have the ability to move ERCs from one property to the other. We cannot create ERCs. We cannot delete ERCs. They have to go on there. And we haven't been looking at that. And what I'm looking at here is, okay, if we told Scott Prepin that he needs to buy another 17 ERCs or whatever it is, we have to decide where those ERCs are going to be, which piece of property are they going to be coming from, because this idea that we've got ERCs in a kitty is another thing that if and I've said this before, I go through the records. There's nothing in our rules of procedures that allow us to take ERCs off of a property. The only thing that we can do is move them from one property to the other. So let's just take parcel 13 for an instance. At one meeting, they were talking about selling this to Brian Jones to put an RV park on. Well, he was told there's, I don't know, a couple hundred ERCs or whatever that number was at that time, and he was going to be responsible for those assessments and on those ERCs the day that he brought that property, right? Okay, he said, hell no, I won't do it. That's crazy. I'm not going to pay you guys $200,000-$300,000 a year on assessments on bare ground. He backed out. So then they went to Lindsay Case's proposal, and Cal in the meeting goes, oh, well, there's no ERCs on parcel 13 anymore. We took them off and put them into a kitty, and we could sell those separately. He said, Russ brought it up in that meeting and said, I've never seen that. I've never voted on that. How did that happen? I look at another minutes of meetings. Terry O'Connell said the same thing. When did that happen? We never discussed that. And so, but all they kept saying was, Cal says they're no longer on there. And he said it enough times to where everybody started to believe that. But what I'm telling you is if you go back, that is not the case. Lindsay Case's property, in my opinion, should have retained those original ERCs, just like the old hotel had like 90 of them on there. Because the county owns that and they don't pay on those assessments, doesn't mean that those ERCs were ever taken from that property. Because they can't be unless they get moved to another property. Because we have no mechanism for a fictitious area that we've got these things sitting in that are attached to nothing. That's not how this place was set up. That's not how our rules and procedures were set up. There was never ever a referendum to the board vote on to remove those ERCs from any of those properties. So I'm saying right now is we actually have to first go back and fix that sort of thing because, like I said, as far as I'm concerned, those ERCs should still be on that property. Now, when they sold that property to Mr. Case, they negotiated away taking the, asking for him to pay for the assessments until he bought them in the ERCs in stages. Those assessments should have been on there already, but he could have paid for them in their negotiation situation, 33, 33, and 34 in a time thing. Cities do this all the time to encourage development to come in. They say, well, we'll give you a moratorium on charging you taxes on your property for, say, 5 years. It happens all the time, but it doesn't mean that those ERCs weren't on that property. It's just that they said, we're not going to assess you on them. We're going to give you a deferment or take that responsibility out of you. And like I said, it's the same thing with the old hotel property that had like 90 of them on it. That property owns 90 ERCs. If Collier County were to sell that property, those 90 ERCs should still be attached to that property because they couldn't legally be removed from it. They could only be transferred. So, and I've got the records here, and one of them is showing how ERCs have been transferred over the years, and they go back to like 1993. For an example, Stella Maris, multifamily, had 144 ERCs on it, right? In 2011, that went down to 108. So in other words, there was 36 ERCs that they're no longer assessing Stella Maris on. Why is that? Because those 36 were transferred to another place building condominiums that needed the ERCs. So they didn't just disappear off of Stella Maris's property, they were transferred to another property. And this goes on multiple places. Southwest Commercial had 48 on it in 93 and only 4.4 in 2011. A difference of 43 and a half ERCs. Those went to the condominium association right next to it because they needed ERCs to be built on, to build their condominiums. So what I'm getting at here is this is a pattern that shows ERCs have never been moved to nowhere, to a phantom account. They have been moved from one piece of property to the other. That's the only thing that they could do. And they didn't even have a mechanism in there for the board to take them back. There was no mechanism in there for that. In fact, as it says right in, the attorneys on there have said, well, if you're going to do that, we have to we have to change our assessment method, or I mean our rules of procedure. We have to change that stuff because under these rules, it can't be done. Those rules have never been changed. So that's a whole nother complexity that's going to be going into this. Because I'm looking at this too now, and I'm looking at Scott's situation, for an instance. Okay, back in the original, there was 18.8 ERCs on the marina, 18.8. And then they went to it and they said, okay, how many more is he going to need? Well, at that time, they were doing the math at 0.12 for just a regular water dock, 1.2. And the other one, the liveaboards, was at a 0.4, okay? So then they took the difference and they added that up and they said, okay, he needs 37, let's just say, throw that number out there. He needs 37 ERCs according to this math. He has 18, that's why he's short the 17, right? Well, I'm looking at this now and I'm saying, okay, just like those other properties, if we said to them, you need additional, in other words, if the math was originally done at a 0.12 and now you're saying it's going to be at a 0.25, you have to redo that math because now all of a sudden they're going to need 50 ERCs under that scenario. And where are those ERCs going to come from? Well, what we do is we could transfer them from one property to the other. In other words, we could, well, we can't now because Lindsay Case owns them, but let's just say we could go to the county and get them to transfer over the additional ERCs from them to Scott or whatever. But what I'm saying is the way we're trying to do things here, it isn't legal. It's not practical. We just can't do it. And the reason is I'm looking at this and nobody else is ever looking at this stuff. But I've looked at it hard and long. And that's why I keep asking the attorney at the last meeting, show me where O&Ms were never transferred along with regular ERCs. Well, the same thing that I just came up with here showing that Stella Maris North transferred 36 ERCs away from their property, I'm not seeing anywhere where Stella Maris North has got 36 O&M on their property more than they've got ERCs. And you just go down the list. O&Ms have always transferred to all these things. But this is getting back to why we're going to have, why this is complicated. Because it's not going to be just, whether or not we can force Scott Preppen's Marina to buy more ERCs. It's how many ERCs does he need? Does he go back to the original? Or does it go back to what it should be now? Because we're going to go back, or we should go back, and all these others, like the tower, the Mr. K's property, all these properties that we added more assessments to need to buy ERCs because we can't create them. And that's essentially what we've done. Any feedback on that? I know it was long and windy, but.
Yeah, I get feedback. I get feedback. It sucks. So,
Yeah.
So we need to change it. We need to eliminate, I mean, we can keep, I think we keep the O&Ms as they are until we need to redefine those a little bit. Okay, they gotta be fine tuned, all right? But the ERCs, we need to go to, some type of, hookup charge or, building is like when the county hasn't, when you build, you pay, what the hell is it called? You pay, impact.
Yeah.
So we gotta switch to something else. We have to call it an impact fee or something, just like the county does. And just eliminate all this other stuff. Now, how we're gonna clear up, the marina, I don't know.
See, now that's-
Did they get increased number of slips or they just increased the number of big slips?
Side.
We only increased we've increased the widths of about maybe a third of the docks. We didn't increase numbers.
We
And
added 56 liveaboards. There was previously a liveaboard max that was 56 under what was approved in
we
2018.
changed the characterization of some of the docks, but we didn't go beyond what the original number of docks that we had.
Yes, remember, but you added a lot more liveaboards on there, right?
We changed some of the designations to liveaboard, that's correct. But that doesn't, let me just say that we still have on average 1 or 2 people per boat. Whole families didn't move into the liveaboard docks when we changed that designation. I mean, we don't even hardly have, I don't think we even have 10 more new people actually living on their boats since we made that change.
It's not a
We know
standard
those numbers.
it's a standard legal right. And so I guess if I could respond to some of this, the letter that we have been discussing is a letter prepared by District Engineer Ron Benson making a determination as to the amount that was needed here. It was what was provided for the marina to get approval to add 56 additional liveaboard slips. My understanding of the intent of the board was to enforce the letter. And so now what I understand is we'd like to reevaluate the entire system. I think there is, and I know I've provided this before, it was provided to us by Ron Benson. There's a summary kind of the ERC process over the years. And actually, there's an indication as to what Chairman McNamee is saying in the actual letter to the marina. There's this statement here, which says, CID recently acquired the property to the north of the North Hotel and west of the CID water and wastewater treatment plant. With this tax deed property acquisition, the CID controls sufficient ERCs to sell the marina enough to cover the increase in water and sewer capacity for the subject property. This is on page 4 of the PDF of the utility connection letter that we're talking about here. And that appears to be consistent with what Mr. McNamee is saying. So I guess I want to try to keep what is the focus. The focus here is, can we settle this matter? What I'm hearing is maybe we cannot settle this ERC thing at this time, which makes sense to me. But then my question to the board is, is there anything else to discuss here then? Because I guess the one thing I would point out is the rest of this has to do not with the ERCs, but with the O&M allocation established by the assessment methodology, not by any other means. And so the board is being asked to reduce the assessed 1 down to a 0.5 for liveaboards and a 0.25 for all of the boat slips in exchange for the dismissal of the lawsuit if you drop the ERC component to this. I don't know if the board wants to keep discussing that at this time or take a step back and look into the ERC component of this and come back around to this once we have more of a position on the ERC component.
The thing of it is, this ERC component, I think, is going to take some time. And I'm looking at this lawsuit where it almost seems to me like if we don't do this today, we're going to have to plan to take this to court. And we're going to spend a lot of money to take it to court. And then if we spend that money, we might as well go there, because I think that the district will prevail in the end anyway. But you know what? Anything can happen in the court. I don't personally want to go through it, but you know, you can't shy away from something just because it's uncomfortable and you don't want to do it. I've been listening to Kevin, I've been listening to Dan, and I listened to Lisa, what she was saying on the last meeting there. They're not comfortable with it because they think that we're setting a precedence for the rest of the community, you know? And we've got guys now going around the community that sat in that last meeting are going around and telling them how the district got a beat down because now we're giving in. And, you know, not that we need to listen to that sort of thing, but it does come into it because these other people are looking at this and going, well, I guess they caved on the marina thing. I guess they'll cave on the rest of this stuff. So,
Zach, can't we get through some kind of arbitration or something with all this? No, there's no arbitration.
I think that the court has set a date in September.
Yeah, it's set for trial in September. Lenore, I don't know if the mediation already took place. So, and I believe settlement was not able to be achieved in the mediation.
That's correct.
I'll say this again, you know, if, and maybe I'm being too simplistic, but if the ERC was removed from these negotiation discussions, we're okay with everything else. We could pencil it up and take care of lawsuit and fight about the ERCs once we have a more reasonable basis to argue with it. And I have a chance to meet with the attorneys. So maybe that's oversimplified in my world, but
well, I think
Steve, I'd like to get something resolved as opposed to nothing and just see it dragged forward.
I think it's, you know, that we would be resolving it. As I see that offer, it is not addressing any of the district's issues, addressing all of your issues, and leaving too much open-ended.
I mean, I would agree with that. Essentially, we're, you know, giving in on it. This is the give in to everything would be right here, and we're getting nothing in return. So, I mean, that's essentially what this is.
Say it.
I mean, it is what it is.
You agree with what she just said.
Exactly.
Yeah, I agree.
I do as well. Yeah, we basically would be capitulating on all of it.
Okay, so with that in mind, do we want to just wrap up for now and move forward? I mean, we took a shot at this. We don't seem to have enough information to talk through the ERC piece. That's the only piece the district would be getting.
I mean, I'd like to settle the lawsuit, but here again, I think that the 0.25 and the 0.5 are actually not part of this lawsuit.
That's
We're
correct.
trying to bring it in, but it's really not
That's
part
correct.
of this lawsuit.
That's correct. The lawsuit is over a methodology that you are no longer using, and so the district has previously made settlement offers to try to resolve the rest of the lawsuit. They were not accepted. I don't know if at this time what would be accepted, but in many ways, what could just happen is the parties could stipulate to dismiss the lawsuit, and then we could work through the rest of these things over time as we get more information, because what the lawsuit is about is a methodology that is not actually being used by the district. Okay.
Yes, because once this goes to court, what we come out of that court, the judgment we come out of that court is going to have nothing to do with a 0.25 or a 0.5, just on the lawsuit on its own. Correct?
Correct.
That's correct. So if you essentially wanted to go forward with the settlement without dealing with the ERCs, you're giving them more than what they would get their best day in court. You would be giving them with that.
I agree with you. I'd like to settle this and just part ways on the original 5-year-old legal action, but without the other caveats being put into it. If we could put that piece to bed today so that we don't have to go down this road come September, I think that you might be able to get us to agree to that, but I don't think you're going to get us to agree to giving up or changing the O&Ms and then we can't even talk about the ERCs because we don't know what the values are or even what number specifically we have to be asking for. So with that in mind, Scott, is that anything that you would be open for?
I don't even know what you're asking me, Steve.
Basically, I was hoping that go ahead, Zach.
Yeah, my understanding of what the board is saying is The parties would right now agree to stipulate to dismiss the pending lawsuit, and that would be the only thing resolved at the current moment. We would not resolve the ERC issue and we would not resolve the current O&M allocation issue.
Well, the whole issue is we disagree with this methodology, the 0.25 to 0.50.
But
The board
that's not
agreed to that a year and a half ago, and less than a year later, they changed it up to 1.0, effectively saying that a submerged piece of land is the same as a condominium unit. That's ridiculous.
I understand your position. I think what Mr.
Your own expert doesn't even agree with that.
What I think is being said though is that's not actually in the current lawsuit, and so
No, it's not.
so what I think the board's point is, and it makes sense, and if the board wants to make a motion to amend its counteroffer down to this, it's there's about to be a lot of wasted legal energy on going to trial on an assessment methodology that is not actually in place on the docs right now. And so I think what the board is saying is let's not do that. And then we can, in the time that we have, instead of going to trial, we can try to figure out the other two issues to the extent they are.
You're just asking me to waive anything that we have available in our lawsuit. Just walk away with nothing.
I'm not asking. That's
what you just asked me.
By counsel, I'm saying that they've made a counteroffer before. They don't. After the discussion that we've had today, you've expressed you're concerned with the way the ERC is being done. The board's expressed that they're concerned with how the ERCs are being done. That was the only kind of piece of this that was to the benefit of the district. And so without that piece, it makes sense that the board would modify its offer back down to we'd be willing to do a walk away on the claim. Keep in mind we made offers of judgment, so there's a potential attorney fee recovery the board could go after in the other lawsuit. So I think that, but I don't know that it's worth going too far down this. I don't want to encourage the parties to go too far down the road on legal argument. The hope was that we could some kind of settlement today. I mean, Steve, if you think it makes sense to reduce the scope of the counteroffer, I would suggest doing so by way of a motion. Otherwise, I don't know if we're going to make any other progress today.
Scott, just to make this really simple, what I was talking about is you brought a lawsuit based on specific things, thinking that processes weren't done right and da. So you have your side of the court case. The district's attorneys are telling us that if this goes to court, we're going to win this thing. You think you're going to win? I think the district thinks they're going to win. What I'm saying is, let's not have that fight. I don't think it's worth that fight. I think we let that, but that's up to you. But I know you would like to get some of this other stuff pulled into it, but I don't think we can. Are you following me at all? I'm sorry.
Basically, I think our goal was to get compensated with you paying for those 16.
No, they're asking for the law. I'm talking to Ken right now. They're asking for us to give the lawsuit for nothing.
Reduce the rates. That's the way I thought it was going to go. No, before.
Yeah, before, but we can't because we don't have enough information. He hasn't been able to talk to his attorneys.
Well, we didn't give him a number.
We can't.
Yeah, but then, then you can't settle it.
We can't today. We couldn't do it in 12 hours.
Yeah.
You can settle a lawsuit today.
You can still think you can settle it next week or in August?
No. What we can do today is we can, like Zach was saying, we change our proposed settlement to say we'll walk away from this lawsuit. Both sides walk away from this lawsuit. Nobody wins anything. We don't go back after trying to get our attorney's fees at a certain point, and
Are you talking about eliminating the idea that
lawsuit goes away.
Right. Yeah, but the assessment, everything is still there.
That's different.
I know, I'm just saying, so.
But the thing of it is, that doesn't have to get done in the next month, paying attorneys to do the whole thing.
Right, this is going to be a revenue.
Yeah. You're probably not interested in that, Scott?
Not at all. I mean, we've been talking most of this time about the new rates going down to 0.25 and 0.25 or 0.50, which is where they were a year ago. Nothing changed within that time frame other than a board decision to raise it up to 1.0. We vehemently disagree with that. And no, there's no current outstanding lawsuit against that. Our board's authorized us to move forward to challenge that specific asset because we don't agree with it. So to take that off the table is a non-starter.
Like I say, we're
Let
trying
me
to.
just say this, that it's actually not on the table, period. Because if we go to the end of this, regardless of who wins or who loses, that's not going to change. So the point
Under the
is
existing laws. I
that
agree.
one party is asking for something that they would never get in the lawsuit. It to me, it's only reasonable that the board would ask for something too. So it's in essence, to make this whole thing worthwhile for everyone. Everyone's walking away with something. But I mean, listen, I understand your point. I don't want to argue with you. You're represented by counsel, but the idea is that even if you won everything, that's not going to happen in this lawsuit. So what essentially would you be giving up?
Claims that we have in the lawsuit.
No, that's not a claim in this lawsuit, though. That's not what this lawsuit's about.
I didn't say what it was about. I just said we would give up any claims we'd have under the existing lawsuit.
Okay, so I guess to the board, do you want to amend your counteroffer, leave it out there, withdraw it? We need to, I think it'd be, I don't think I'm just not hearing much further on this. If you want to.
Draw it. It's a mess. I don't care which way you go now.
Make a resolution.
It's not going to work. I think we withdraw it.
Do you want to make a motion, Dan, to just withdraw then, and we start preparing to go to trial?
I can do that. And I make the motion that we withdraw our offer and prepare for trial.
We have a second?
No second.
Do we have more discussion?
Actually, could I ask kind of a question? Part of this is you can't fund the ERCs to transfer?
No, that has nothing to do with this
No.
lawsuit.
Oh, okay.
So
Steve?
Scott, and
All in favor?
Steve,
yes,
this is Ray Jensen. I think I can help you.
Okay.
Scott, listen, let me see if I can put the video on. I can't. As far as the ERCs on parcel 13, that was done by the board before the board I was on. And Dan Cox was the attorney. And when they took over that land, they took it from Bruce Holacek, who was a multimillionaire. You know the whole story there. He owned the RV park and the gun club and everything. He wasn't paying. So in lieu of foreclosure, they cut a deal. Why is that important to you? When they did that, they scraped the ERCs off of it because they're a county entity. They were the CID. Now, that's what we were told at the time. I wasn't on the board. At the time when we had the meetings, they said, I asked them the question because I didn't understand it either. I said, how can there be no ERCs? Now, to go along with what you're saying, the old hotel, when I came on the board, I said, well, what happened to the ERCs from the old hotel? And Cal said, and I'm not blaming Cal, but he told us, and they said, well, we just took them off. I said, okay, so hold that thought for a minute. Everything you've said, Steve, about the ERCs is correct, except for one thing that I didn't understand either. It's all of the ERCs you're talking about, how they're transferred, everything you said is correct. And the only difference being the CID is who actually owned parcel 13. They owned it. So they weren't a private owner. So what I would suggest you do, maybe take a little time. I would call Tony Davis. He was the chairman of the board at the time, or Noreen Dillon. But I would call Tony Davis. He was there. That's when it happened exactly. And I remember asking that exact question. And I remember asking the exact same question about the hotel. And then when I got on the board, I said, this doesn't make sense to me, which to answer your third question, They told us back when I was a citizen going to meetings, and after I got on the board, Ron Benson said it, Cal said it, whoever we could go to for reference, they told us that there is a piggy bank of surplus ERCs that the CID holds. And I don't know where that is. I don't know where it is, but they said that there is a piggy bank of surplus ERCs because the community, Port of the Islands, is not built out. So there are ERCs. Now, I thought the same as you, that the ERCs were all allocated on the properties. However, somewhere along the line, when Holacek sold parcel 13 to the CID, those got taken by that board. The hotel, that board took those same ERCs when Matwani went bust. All of the other properties.
No effect on
All of the other properties, Scott, is private. So the docks is private with the bay bottom. And I think what Lenore's trying to say is you're confusing the OEM classification, I believe. You're confusing it or using it as a lever, but the ERCs is a separate thing. The ERCs are privately owned, and the only ones that aren't is parcel B over here and parcel 13. So because the CID owns them, that's the difference with the ERCs.
Ray, can I ask you a question?
Yep.
Okay. In your tenure on the board, did you ever see a spreadsheet that had a list of where the ERCs were allocated to the private properties?
No, but it does exist. And I'm going to tell you something. Did you guys ever get, when you took over, did you ever get the big white book that Ron Benson did for us? It has every single transaction ever done.
Yes, we have.
I did not see a spreadsheet though.
Yeah, I agree with Mr. Truckee that we have this binder and it references the spreadsheet that you're talking about. However, I don't see the spreadsheet in the binder.
I've never seen the spreadsheet either.
There's a paragraph in there that very clearly references a 2021 spreadsheet that is exactly what we're looking for. It's not in the binder to my knowledge. And I've provided this binder to current district engineer, I believe also Mr. McNamee, but there's no spreadsheet in the binder.
I know where it is. I believe when Russ Wire did his thing, he generated that. In fact, I'm sure of it. If you look at Russ Wire, when we hired him to come in and analyze the whole POI, he generated a spreadsheet. That's where it is. That's where it is. Because I remember there was a question about the bar seats in the restaurant and how many seats and what they were worth. And I remember the gun club was one of them. I think you'll find it there.
Okay, Ray, and I don't want to beat this anymore because we beat this to death already, but when you talk about, let's just say parcel B, for instance, because the CID bought that property, right?
Yeah.
Doesn't mean because the CID bought that property that those ERCs are removed from that property, because tomorrow we could sell those ERCs, or we could sell that property again, and it would have 18 ERCs on it.
I agree with you.
For removing them.
I agree with you. With you.
Okay.
What happened with parcel 13 is unique. And that is how they explained it. I was a civilian. I was sitting back there just like anybody else. And that's what they said. They said there are no ERCs. In fact, Dan Cox, the attorney, I said, why would you do that? And Dan Cox said, so that when somebody buys it, a commercial enterprise, we can customize it to their needs. That's exactly what he said. So whether it was right or wrong, that's the only parcel doesn't have ERCs on it because it was CID owned. That's what that's what they've always told us.
Well, let's save this fight for another day, but I do appreciate the info, Ray.
Yeah.
Thank you.
So there was a motion and a second, but I don't believe there was a vote.
Was there any more discussion on this?
That was for withdrawal, right?
Yeah.
Remove the offer.
Scott, is there any reason for us to modify it?
Well, I'm going to continue to look into the ERCs. I'm not going to stop digging into that exercise because I want to resolve something here, but there's just not enough information to resolve it today. That's how I feel.
Like I said, we're trying to separate the lawsuit out from.
I understand. I understand.
We're up against the clock on the.
Yeah, I'm not going slow on any of this. I worked all weekend on this thing. So, you know, my attorney's back in about a week or so, and then we'll re-engage with him as soon as he gets back.
Okay,
Well, there's a motion out there. Are we going to vote on the motion or what?
well, yes, we are. But what I was trying to do is give him one more opportunity to put this to bed because we could still modify the offer. But if it's going to be no, then let's not bother our time making it. So that's what my question was. Is there any way that we can make that work in your mind, Scott?
If you're just asking me to walk away from the lawsuit with nothing, then no, my answer is no to that. That's not changing.
0.5 and a 5 back in. 0.5 back in.
That's the direction I thought we were going
Agreed to
in.
that, right?
Yeah, put
In
it
their
back in.
offer. Go ahead, Ken. Ken's on the.
They already agreed to the 2.5 and the 5, right? 0.5?
Yes, in addition to the ERCs. There were three
Okay.
components.
We have a first
Yeah,
and a
it's just
second
just thrown at us lately. It wasn't, we didn't know about that before.
vote.
Why can't we just take the two issues, the lawsuit and the 2.5 and the 0.5, and then make that the motion? Then we go forward.
Yeah. Oh,
That way we both win.
No.
Yeah, as the district has stated, that would not be a win for the district. But I believe there's a motion and a
So
second.
it's all depending.
Mr. McNamee?
What are they losing? If they're not winning, what are they losing?
Revenue.
okay, let's vote on this. All in
Not
favor?
everybody.
Aye.
Ending the offer? I think it's unanimous.
Yeah.
Yeah.
Yes. Aye.
Sorry,
Aye.
Scott. We tried again, didn't we? Did I lose him already?
Zach, can I ask you a question?
Yes, sir.
Because we reopened it, well, we didn't reopen it. We kept the same meeting and we just picked up business today. Can we talk about anything else or was that the only thing we could talk about today?
I mean, it was continued for this purpose, but we did it's not a special set meeting. I'll leave it in the chair's discretion. I don't think there's a strict prohibition on continuing discussion if you have other items you'd like to go over.
We just extended the meeting.
Yeah.
Correct.
So we did. So yeah, so we can, in fact, now that we're here, let's spend our time figuring some of this stuff out. You had some more things that you wanted to discuss.
No, I don't want to get into that stuff.
No? Okay.
Not until we get the budget done.
Do we want to talk about how we're going to handle the water bills? Are we comfortable with what Neil is proposing? Yeah. Mute that. Mute that.
You know what? I don't know where he is.
Oh,
He was just on the screen.
okay.
And call you.
Still on the screen.
He just left.
It's nothing.
There he is again.
His computer's still.
I'll put it right back. Just call.
I don't want to listen to his private conversations.
Have a mute.
He's trying.
Dave, can you mute him?
He's trying.
Dave is, okay.
Computer-based per tax ID member. So good thing.
Well, let's just go now. I'm not hearing him anymore. So what else do you guys want to work on? This water
Sure,
thing?
talk.
Go.
Okay, go ahead. Work on the water.
You want to work on the water thing? So Neil gave us some ideas of, the numbers that he was talking about last time for meters or, base charges. Have we fleshed that all out? Is this something we can go forward with?
I think it is, as long as those corrections go into the final bill that we made last time. I think I'm good with it.
Neil, are you there?
Yes, I'm still here.
Is it, are you comfortable with what we've got going, or do we need to talk
I
about
am,
something?
the one thing that I need to do, and I'll be back next week, we are going to revise the irrigation charges to eliminate the tiered structure. I think
Yes.
there was unanimity on the part of the board that we're going to charge a base rate, and then we're going to charge a commodity rate per thousand that is the same against all residential customers. The other changes that I reviewed as they relate to late fees or meter read fees or shut-off fees, I think the board was good with all of those. And then keep in mind that this is a 4-year rate calendar. It is subject to annual appropriation, but the rates are going to creep up about 5% a year between now and 2028.
Do we need a resolution then to accept what you're speaking of, or?
No, you're going to adopt the new rates when you approve the final budget at the August meeting on the 15th.
Okay,
Well, wait a minute, you said something about a 5% increase per year?
that's what our
It's
consultant was saying that we should be doing.
It's gonna do that automatically?
No.
So are we gonna have to vote on that?
No, it's not
every
going to
time?
automatically do it.
Okay.
We have to do a budget every year.
Okay.
Yeah,
So-
there is a sketch. Go ahead.
Personally, I'd like to move forward without an increase this year if we can. We'll get this ERC thing and this base meter charge in place and see how that looks. And we do have some money in the bank at this time if we're short. I would like to at least start out on that and move forward and get this done, and then we can make some changes.
Right, let's send the water bills out, see how they line up with our budget items. If we're above that, we can vote to lower it. If we're below that, we can adjust it up if we have to. But you've taken your best guess as to how this should pan out. And I think, you went through that work. I think we should go with that. What do you think? Okay. So I'm good with that. What do we move on to next?
Talk about a building.
Okay.
Some time ago, going back a few months, we spoke about a community building. Since then, we've talked a little bit more about that, and I think that we should look into going with a multi-purpose building, something that would be for the community. It would be utilized for hurricanes. It would have generator power. It would have a place to put out some cots. It would be to elevation, so we don't have to worry about the floodwaters in it. It would provide our community with, I think, a needed place to go, especially for the elderly. Take Irma right after the hurricane. It was back to 95, 98 degrees and humidity of 100% with all the floodwaters. And people were in a dire spot there that stuck around. So I think that building, if we built a community building that would have a multi-purpose feature to it, that would be something that would be a great amenity for our community.
Now, the first thing is, you got a copy of this thing that Frank Lee sent out, right? About whether or not we legally can do this? Did you see that? Dan?
No, I did not read that.
It was entitled, yes, you can build a public safety facility. And this paperwork, basically, that he sent out goes step by step through the entire process. Funding it, noticing it, everything. The blueprint is right here. All we have to do is follow this blueprint. One of the first things that we would have to do is change our CIP. And our management or attorney has to tell us when we can change a CIP, because the first thing that we would have to do is include what I'm calling a public safety facility. That would be the first thing that we have to do before we can even start down this road because of how it's going to be funded and everything else. Neil, can we change our CIP today?
I mean, you could vote to change the CIP. The CIP, I don't believe, is embedded in your rules of procedure, and so we're not amending anything. Typically, I think a good time to do that would be at the end of the fiscal year in September, so that if we were going to carve out some money and do some sort of design build project, we could reflect a budget amendment to get us through I'll call it the preliminary design and permitting phases as part of next year.
So
If you wanted to ask me, to bring back a revised CIP in September, we could do that, and we could use some assumptions to look at the funding implications of that and what borrowing might be necessary.
well, I can get this to you because, I mean, it's got everything in here. It's got all the laws, the statutes, the whole 9 yards, and the steps going through it, who you might get financing for, all these things. But I just wanted to give a quick idea of, we've been talking about a community center, which, we get pushback on. But, we've talked about trying to sell our water treatment plant. We've been trying to do all these different things. If we ever got rid of the water treatment plant, then we would actually have to have a building to put our generators and everything else in because we no longer own it. But what I'm envisioning myself, and I've talked to a bunch of different people. In fact, as I talked to the board president over at Newport the other day, and I bounced it off of her, and I said, here's what I'm envisioning. That we construct a building that is set up for times of trouble. So in other words, we're going to have a place now where we can put all of our generators in it instead of having them off-site. Okay, so we had a couple of hurricanes ago, we had a point where there was 2 or 3 weeks in here where there was no electrical, right? I'm envisioning this building that we set this up. First of all, they say we're going to have a hurricane, right? Well, the first thing is you work with the county and say, you're going to need a place to stage your safety equipment or your rescue equipment, just like they did over at the hotel at this last one. They had the hotel parking lot was full of generators. You have another place where they're full of electrical trucks, maybe ambulances, I don't know. But because of our location, we wouldn't only just have that building, but we would have the acreage necessary with it to work with the county and say, all right, stage your stuff on our property here and fan out from here, but you've got a office set up here for this, and in exchange for that, we can probably get some funding out of this, okay? And when you don't have power and you've got people here, first thing I look at is refrigeration. You got a lot of people who got medications that have to have refrigerations. Yeah, they can have generators, they can have all that stuff, but you know what? Every time somebody starts up a generator in this community, there's always a risk of somebody dying from carbon monoxide because they didn't do it right. But that's not a good enough reason, but it is part of this. And then the other thing is,
Steve, if I may, the first thing that comes to my mind when we don't have electricity is if we have any elderly people on oxygen concentrators, because that's pretty common when you get older. And that doesn't work either.
absolutely. All those things put together, plus the fact that elderly especially can't tolerate the heat. Well, we set this place up so that we're going to would have a kitchen facility in it. And then also we would have a whole bunch of cots or mobile beds or whatever you want to call them, inflatable beds, whatever. But if people wanted to in the evenings, they come to this safety facility and they can stay there at night. They can cook their foods, they can do whatever they want. Or they can stay in there for the 2 weeks it takes for the electricity to come back. But it's If you look at the people down south that just had the flooding and all that sort of stuff, nobody is prepared for a catastrophe. Nothing's set up, nothing is in place. I'm looking at this and I'm saying, look what's happening to our weather. It's getting worse and worse. More hurricanes, more winds and everything. I'm hopeful that we're going to be able to get this FEMA funding, and then at least a good portion of it. We also have a lot of money in reserves. I think this is something that we can afford. And also, on something like this, we can get this other funding where they're low interest and maybe they forgive some of it. I mean, there's a lot of things, but what we need to do is we need to start looking at this. We can't just say, we're going to do this. Because right away, people are going to get up with their pitchforks and say, hell no. Well, we're not to that point yet. And people say, well, where are you going to put it? And I'm saying, look, we don't worry about the dirt we're going to put it on right now. What we do now is we design a concept. You know, we get a contractor to come in and say, what do you want? And this is what I envision, and this is what that building will cost you, right? So then after we've decided, okay, we're willing to invest that amount of money into this facility, then we start saying, where do we put this facility? Well, we have a bunch of places that we could put it in here. We could put it on parcel B, which we already own. We could put it on, we could try to get the land from the old hotel property from the county. We could put it on there. Scott Preppen's probably got land over there on 41 that he'd be willing to sell. I've got property that I would be willing to sell, but there are other places that we could put this in. There's actually some land in Orchid Cove itself across from their community center that the county owns that it could be built on. I think it's too small, but what I'm getting at is let's not focus on the dirt right now. Let's focus on the main project. Let's get this going and saying, you know what? We have a right to build this by statute if the board decides that it wants to do it, okay? Then we come up with the preliminary ideas of what's going to happen, what's going to cost, before we start going to the public and saying, what do you think? Because you can't go and get intelligent answers from people if you haven't given them the information that they need to make it an informed decision. So the first thing we have to do is start going through these steps and coming up with what this is going to envision, what it's going to cost, and whether or not we feel it is worth the investment.
Okay.
Steve, would it be worth making a motion to put like $5,000 down or something and say to come up with an idea of a size building and I have no idea what it's going to cost, not a builder. But if we could come up with just some basic ideas on what it would cost, is that a start?
Yes.
It takes a few dollars to at least you get a plan.
I think right now is a perfect opportunity too, because building is basically almost slowed down to nothing around here. A lot of people have quit building. So building costs are going to start going down for the first time in a long time. So this might be our one opportunity to do that. And the fact that we've got our water plant is completely done now for the most part, except for the water lines and the other few things that we're looking at. We can handle that. You know, before we were paying $500,000 a year on retiring a bond on that water treatment plant. That's all gone away. But our assessments haven't gone down a whole lot. They've gone down a little bit on the utility part. But under current conditions, my opinion is I think we can afford to do it. And I think it would be in our best interest to look at doing it. Not saying we're going to do it, but we should start the process. Like Dan just said, I don't know if we need to hire an engineer to come up with that. You know, I don't know yet. We could get the advice from some contractors, find out. But, and if you want to set aside $5,000 to say we will retain an engineer, I mean, we could do that, yeah. I'm the guy who's always looking for the cheap guy, though, or I mean, the way not to have to pay for it. But maybe we can't do that. But yes, let's start the process.
So Dan, make the motion.
Oh, just hold on really quick. On the procurement side of this, just so I understand, one, could I get a copy of that document that you're talking about?
Absolutely.
Thank
Yep.
you. As far as what the money is for, is it is it for engineering? Is it because there are special procurement rules when it comes to engineering? So I'm just trying to understand how the money is going. I understand it's a fit test to try to figure out what kind of building this is, but
And
That's
I,
what Zach, I'd say that that's kind of what it is a fit test. I don't know if we say we want a 300 square foot building or we want a 1,200 square foot building or whatever it is. I don't know what they cost. I couldn't tell you what the dollar amount is to get an idea of what not an engineer, maybe a builder or somebody can sit down with you and say, well, 1,000 square foot buildings can run you about this much, a 1,200 square foot building about this much, and get an idea of maybe a fit as to what we could work with, the dollar amounts we can work with. I think it would cost, I don't know if it'll cost us 5,000, but it'll cost us something to probably sit down and have somebody give us an idea. That's what I'm looking for.
preliminary analysis. Yeah, engineers typically do engineering opinions of probable costs for various projects, and so they do have something. I wonder if your retained engineer has someone on staff that could assist with this, so that we don't have to, because they've been retained as your district engineer as is, so there's less procurement hurdles and using them to solve some of these problems. Neil, do you have any thoughts on, because this is kind of an open-ended assignment. I just want to make sure that we don't step
Yeah,
into
I would start with Johnson Engineering, only because they serve as engineer of record. And if we needed to engage a designer or a builder to prepare some elevations or renderings as to what the building might look at, given some what are called programming assumptions to try and justify, like Dan just said, is this a 1,200 square foot building or a 2,500 square foot building? Given some what are called programming that then equates to square footage. I think we could start with Johnson, and if they needed to engage somebody as a sub-consultant to prepare some elevations or some renderings, then that would be where I think we would start. I think we really, again, I would hope that we could wait and have the initial conversation, at the September meeting, only because we're kind of focused on budget and getting the assessment roll to the property appraiser and getting the utility rates revised and uploaded over the course of the next 60 days. We're kind of busy right now.
So
I think it multitask.
If I may, everything seems to take longer than you ever plan it to. That's just the way it goes. Would it hurt to do set the 5,000 aside and talk to the engineer and maybe they can start throwing something together? We're not going to probably see anything to get approved or do anything with till September anyway, but
right.
I think that's what we're saying.
Maybe they can come back with us and give us an idea what they think for a multi-purpose building for the size of our community. We need this many square feet and it would cost you about this much money. Maybe they could come back with just some stuff that's just killing time if we wait till September.
Yeah, and I think if I needed a little more than 5,000, I would tell the board that when I see you in September. But I'm not opposed to getting the thing in, getting the project created and engaged. And I just think we ought to go with the engineers who already have the working knowledge here.
I'm fine.
Just to make sure you don't cross a procurement tripwire. You've already retained Johnson. This is something that they can do. So
Yeah, let's not, in my opinion, I don't think we should, authorize the 5,000. I think we should go to the engineer first and ask him for his input. And if he thinks that we need to hire an architect or somebody else, then we come back and either authorize the money or we don't.
Can we spend a little bit of money if we go to Johnson, go to Jared and say, can you give us, what does a 2,000 square foot building cost? What is a 15, for our community, what do you think we need? You got any ideas? They have these kinds of centers built in different communities. So I'm sure that he could give us an idea of what we're talking. This building is going to be, I have no idea, $500,000. I don't know. I don't know what. So.
Yeah, I think that makes sense. So and just as some comparatives, I mean, if it's going to be a storm, I heard a lot of descriptive language here about what kind of building it is. And if it's going to be a storm resilient building, you can look at some of the recent builds in Marco and in Everglades on their public buildings. They are quite extent. I mean, Fort Myers did its fire station at 11 million. And obviously it's a fire station. There's a lot more going on there, but a lot of the cost had to do with storm hardening of the building. But I think what I heard was, and this makes sense, that there potentially be a motion to authorize Johnson Engineering to. Do you want an estimate from them, or do you want them to just do $5,000 worth of work to tell you what this building looks like?
Well, I think he can. I think Jared could give us an idea real quick. It'll cost a little bit to for my time to throw together a quick sketch or do some size models for your community or something to get it started, so we start getting some ideas of what we're talking about.
Yeah, it'd be nice if we saw an elevation and maybe a very crude, floor plan that would designate certain areas that in turn could have so many cots on it, or what the equipment room might need to be. But I think we can do that.
I think that, and I'm hearing this part about if you built a hardened building to withstand direct hit hurricanes and so forth, like the fire departments not do. I don't know if that's going to be in our budget. I don't know that we're looking for a building that can be designated at that. I'm thinking more along the lines of building a building that would be the support after that, because I think that cost is going to be substantially less.
I agree. This is a building that would survive a storm and serve as a relief station to the community post-hurricane. We don't want to try to build this thing to, a hurricane evacuation building, and because that entails a whole nother level of liability.
Right. Yeah. I don't think we can afford that.
I had a question. Engineering, we know what we pay for engineering time, and it's really expensive. It's expensive. Engineers are expensive. Would it be cheaper to maybe have a builder or somebody just throw some ideas together before we go to engineering? I'm sure it'd be a lot cheaper.
I've done some work recently with design build firms who have in-house, designers or architects, because I didn't want to go to the separate process of having to hire an architect to prepare a set of construction drawings and then put those out to bid. We did 2 projects with design, build, and a guaranteed maximum price. And I'll think about that. The one firm in particular is Houchin Construction. They have a in-house architect and design team, and so that might be a better alternative. I'll evaluate both.
I don't know that we need to go to engineering first, because that's expensive. And if we go to engineering, I'd like to have something for him to engineer and earn his money.
Yeah, but if what we're trying to do is conceptual, then I think a design build firm. I've got Houchin, and then I've got Heatherwood Construction that have been doing projects for my clients at Pelican Bay and Pelican Marsh last year.
But you don't
good.
Go ahead. Design build, right? That's part of their process. Am I wrong on that, Neil?
Say it again.
So when you go to a firm who's a design build, you tell them what you want. They come up with renderings or whatever, and they come up with the price. But generally, you don't pay them in advance for that information, do you? I don't believe you do.
Yeah, I think that if what you're trying to do is create some elevations or some floor plans, and they're going to spend, I'll just pick a number and say 50 man hours on that, they'll want to be paid for that.
Okay. All right.
And then what we would do is ultimately we would issue an RFP for design build firms to both plan and permit and construct at a guaranteed maximum price a project.
Sure. Is there any more on this for right now?
No, I think so. I've got enough.
So Neil,
Okay.
you need a motion, or is any money being spent, or are we just saying that you're going to go identify?
Yeah, I think Dan's suggestion was that we would spend up to $5,000 to produce some renderings or some floor plans as to what it might look like.
Does the board want to do that or wait? It's up to you guys. Do you want to tie down 5,000, not to exceed 5,000, or do you want to try something else? Lisa, what do you think? Ms. Hanson?
Sorry, I was muted. I didn't realize. Yes, let's do it.
I think, I don't know, in my opinion, to get anything started, it always takes a little bit of money to get something
Yep.
started.
Okay. Do you want to make a motion, Dan?
I make a motion that we are able to spend up to $5,000 to get some ideas and possible renderings of what it will cost and what it would look like to build a multi-functional building.
I second it.
All right, been moved and seconded. Any more discussion? All in favor?
Aye.
Yeah, that's unanimous. Next, one quick thing is I went around with the gal over, the board president, Cynthia. She was here at the last meeting on Friday, and we ran out of time to let her in here, but we went around on the bike, and I know this is your job, but sure. What she would like to see is the meridian between the two lanes over on Newport Drive, have the bushes cut down to like a maximum of like 2 or 2.5 or 3 feet or whatever, because she's saying that people are backing out of their driveways and so forth and coming across, and they're not being able to see through these areas. Right. And she was hoping that we could, bring that down. Right. Now, if you want to look into that other thing was over there at the fire station. There's a sidewalk that comes off of the parking lot from the hotel, and it goes kitty corner over to the fire station there. There's a great big high bush there that's head high or higher. And she was riding her bike past her, and an Uber driver came around the corner and put her in a pile and hurt her quite badly. And she's asking that we could, get that cut down. I've looked at it. I would remove it, but that's your deal. Sure. Okay?
So,
anything else on that?
While we're talking Soto, that retention pond back there, I climbed the weir. There's like a tree growing in there. I don't know if we gotta cut that, but we gotta get the trees out. And I mean, I don't think he has to take a lawnmower in there and cut that down. It's just gonna fill it with water, just a retention pond. But we gotta keep the trees from taking it.
I talked to Soto a couple months ago. I mentioned that to him when I was talking with him about something else, about those trees sticking up in the ponds, and that I thought he was under obligation to take care of that.
Yeah.
And he was
great.
Yeah.
Maybe the other thing I wanted was that, I know it's, this is kind of off but I always wanted to put something between the gun club and the rest of the community. Even if we just put it on that weir. No, I'm talking right along the edge there. Just grows the freaking hedges that we've been doing, those, whatever those things are called that we put in.
Between Lindsay Case's land and the gun club?
Yeah.
You don't own anything there.
Not even on the gun club side. I mean,
on the gun club side, maybe. No, that'd be the gun club.
Because you put right at
the only place that we have it is the retention pond, which is only about halfway.
Yeah, so you start it there and then just work it along the gun club and just those ones that go 20 feet high, just to try.
I tried to talk the board into this a couple of years ago about when we still own that property, what groves in there, which it didn't happen. But yeah, anything that you put in there, it's going to do two things. It's going to help stop the noise, but it also, the prevailing winds come across there, and when they hit those trees, it will push everything up. The currents, air currents. So any of the smell that's coming from that water treatment plant at that time will help to elevate that smell above the population. So it's a twofold thing.
Yeah, I just thought it would help Orchid Cove a little bit.
I think we could talk to Soto about looking into that, right? Okay.
And then the other thing was, are we ever going to do? We're not going to do supplemental mosquito spraying or anything around here, right?
Whatever the board decides.
Well, no, I mean we were talking that we were going to sell that sprayer.
Oh. And then we could get rid of that ugly container over there too.
Well, everything. Yeah, I think rid of the whole thing. So, naturally, you know why I'm asking, so that's,
I don't-
I can't get in on it.
I'm
I
not
just-
sure that, what does the rest of the board think? Are we ever gonna do our own spraying again while we've got,
Once you're in control of mosquito.
I would think
you
not,
you
but-
can't get out.
that's just me.
Dave, it appears that Collier County Mosquito Control with some complaints, and you can do that by either calling them or just jumping onto their website, and they got a big button you can push on the website that takes you right to a report for getting some more mosquito spraying. But they said, the lady there told me that when they get a couple of requests for more spraying, that's included in what we already paid for. They come out and do it.
Well, here's a question I have. How much chemical we got laying over there?
I don't know.
I'm thinking that,
They were like $3,000 or something.
I'm thinking that chemical, we should go spray it.
Use it up, and so they
Just go use it up.
That's,
I mean, I can
We-
find mine. I don't,
but you can't.
oh, I can't, I don't have a license.
We,
I would talk to Collier County before I probably did that.
Okay.
they are aware of the fact that we kept, I believe, $5,000 in our first year budget to do supplemental spraying at the discretion of our board.
So could we hire our previous applicator to come
Sure.
over here periodically until we use that chemical up?
Sure.
Okay.
I don't want to get in it.
Go ahead, just
No,
say
I
it.
just mean, I don't want to use the previous one, then maybe they got to put that out for bid or somebody if they're going to use, because whoever does it, they just need a license.
Because the previous guy ran the damn equipment, he knows how to do it.
Well,
He knows
I
everything
know,
about it.
but-
And I know your conflict in there,
Yeah.
yes. You don't want the community
Right.
saying that you're a bad man.
Yes,
Yeah.
so,
Well, what I'm saying is that his application costs aren't going to be very high in comparison to us letting that chemical go to waste. And I think now would be the perfect time to do it. I mean, I'd be in favor of him coming out and doing it once a week until it's gone.
well, that's like Dan said, we got it run by mosquito control. I don't know how much they're going to let us
Well,
spray.
Neil just got done telling us that.
I know the money is allocated, but I mean, the amount of chemical that's.
Well, we can make a call, that's not a big deal. I'm sure they're not gonna tell us not to.
It's still going to be cheaper than us trying to get rid of that chemical.
You know, the mosquitoes that are around here now, I tell you what, maybe we spray twice a week or, or 3 times a week. I don't care, let's do what we
Let's
can to
use
kill
it.
these mosquitoes with chemical we've already paid for.
Yeah, I think we should use it. Is it still good? Does it expire?
As long as it's not kept in that back.
Well, even if
container anymore.
even if it doesn't work, terrific, it's still gotta go somewhere.
I think we pulled it out of the heat, right? It's inside the.
I think you're right. So, do we need to make a motion to talk to our previous fellow and ask him if he'd be willing to come over and help us out getting this spray out in the air? We need a motion for that, or can we call
So I assume you're paying him for his services. He had a contract before that has been terminated as a result of the joining the district. Is that a
him?
correct?
I would assume so, yes.
Neil, do you have any awareness of this old contract and what the terms are?
Yeah, it was Mr. Kish's his son's licensed pest control company in Lee County.
Okay.
I don't know, I mean, who,
No, he's not Lee, he's Cali. It's Cali.
We have no idea whether this person has any availability or not, or what their price is, or how much they would charge to do this. And we know that they're
Yeah.
licensed to.
you know?
Yeah, I know.
Just tell me.
Because I asked him, I said, because he was interested, he wanted to know about buying a sprayer,
Okay,
okay, because it's used.
yes.
But he said if it came out now, it'd be 500 in the application,
What was it before?
325 or something like that. 350. That's why I say.
I wonder if we could work out a situation where he comes and does all this work and eventually he ends up with the equipment that's gonna be worth not much.
And it's certainly surplus property. So I mean, I don't know that we'd be able to direct place this other than take it to some kind of auction. I mean, I'd like to be given time to review that. I'm not sure that we
I'm
can
into
just.
horse trading,
Gotta do it the right way.
into horse trading. Okay, I just think that you know, we've got the ability out there to kill some more mosquitoes with a very minimum cost. Tell them we won't let them have to charge us 500, it needs to be the same as before.
I don't know.
Last,
He's so busy, I don't know. That's it. That's the way it goes.
I bet he could hire
He did hire somebody.
he could hire a flunky to do it then.
Not me, I do that.
Come on.
But
So,
he'll give him a call.
We don't have a contract before us, so we're just kind of, I'm not sure I understand what the action would be. We would just be saying that we're going to go to a prior contractor and ask if they're willing to do the spraying for the same price that they did before until we run out of chemicals.
and
Yes.
pay them on a per application basis.
That's right.
Okay.
In favor of that?
I think that, and I assume, Mr. Kish, you're going to recuse yourself from the vote.
Yeah.
And so,
Not even.
Well, I make a motion that we reach out to Mr. Kish's son and see if he would be willing to come back for what we were paying him for before and use up that chemical until it's gone. Do I have a second?
I'll second it.
So,
Agreed.
All right, that's unanimous then.
I get it.
What else do you want to talk about here now? We're already over time, but
Yeah.
What about security? Were we supposed to talk about that at all?
yes, we were. We had that petition with all those names on it and we sort of dropped the ball on it.
No, Neil said he was gonna look into it.
this was brought up in the meeting. It's been added to the task list. Well, it was already on the task list, but it was noted that this would be addressed in September. I believe this was on Neil's portion. of
Oh, okay.
Yeah.
All right.
Discussed this on Friday.
Yeah, we did. Okay.
Okay.
Okay. Time to adjourn.
Oh, you just sit still. Oh, I had some people over the other day and they're trying to find out where our properties are and so forth in here. I've got an application, it's a hunting application called On X. I've been using it for years. I can press on that on any property in Port of the Islands. It'll draw a line around what the boundaries are of that property. It'll tell me who owns it, what their tax is, how big the area is, all those sorts of things.
The thing we paid for.
It's basically what that GIS was supposed to do for us, which,
We hired the wrong people, apparently.
well, I've been paid, you know, I've got the plan where I can do this on all 50 states. We can get a plan for like $50.
but the
Just in Florida.
But I'm sorry.
the tax appraiser, tax appraiser's website, I go on it all the time. It'll highlight the piece and tell you who owns it too. Same
Yeah.
thing.
You can get the same info from the county.
You know what? Dave showed me that yesterday and I agree with him. It's just some of us are damn illiterate. We can't figure out how to run it. But
Oh, well.
probably maybe I'm just the old guy who can't figure it out.
I tried looking at it.
Okay, let's let that one go then. Anything else?
This is understandable.
Russ Weir, we were gonna get together with him. Someone was gonna get together with him, right?
I have called and texted Russ as soon as I left the meeting last Friday afternoon. I have not yet heard back from him.
Yeah.
Okay.
Task list item 11, you all requested that Russ Wire be at the August hearing so that you could ask additional follow-up questions about the allocations, especially to parcel 13 after.
And he just needs to come Zoom. He doesn't need to drive all the way here. But
I told him that Russ plays amateur ice hockey at a very high level. And he goes to tournaments and whatnot. If I don't hear back from him by this time tomorrow, I'll recontact him.
okay.
Great.
You ready to adjourn this meeting?
Yes.
Anybody here, comments? No?
Great meeting.
Go. Make a motion.
Make a motion, we adjourn the meeting?
Second.
All in favor? Aye.
Aye.
Thank you.
Well, we didn't get accomplished what I was hoping for, but we
No cookies,
tried.
no working.
We tried.